So let's continue with Title 5 on bylaws. Now, Section 45 and 46 are best read together. So here, Section 45, the adoption of bylaws. So I won't read it word for word. What is required is the affirmative vote of the stockholders representing at least a majority of the outstanding capital stock. So majority. Yes. The bylaw shall be signed and kept in the principal office. A copy should be certified by the majority of the directors and countersigned by the secretary, which should be filed with the commission. Now, the second paragraph talks about pre-incorporation. So, if you read the second paragraph, it means that the bylaws need not be filed prior to incorporation. It can be done after. For those of you who are familiar with the previous corporation code, the previous corporation code required that the bylaws be filed within 1 month from incorporation. Now, under the revised corporation code, there's no such limit. In any case, whether the bylaws were filed before or after incorporation, the effectivity will only be upon the issuance of the commission of a certificate. And that certificate will allege or will attest that the bylaws are in accordance with the revised corporation code. So the last paragraph talks about the requirement for an appropriate government agency to issue a certificate for particular corporations, and these are the ones enumerated here. Yeah. Please pardon my handwriting. Now, for Section 46, you're gonna have to remember this because it's kind of self-explanatory already on its own. We'll just need to make a few clarifications. In the interest of time, I won't read it anymore. So just note that it says may. When you say may, it is not required. It's permissive. If you look at A and B, if you compare these two, you will notice that when it comes to meetings of directors, it's just the time, place, and manner. However, when you talk about the regular and special meetings for stockholders, you can also state here the mode of notifying stockholders. And you will see why later on when we talk about meetings under Title 6. For letter H, which I will discuss again later when we talk about the election or appointment of all officers other than directors or trustees. The reason why is because appointment for directors and trustees is covered by Section 23 in the manner of election. Okay. Now, the portion on the arbitration agreement is actually a new provision, and as I've mentioned in the introduction to the revised corporation code, arbitration is a manner of solving disputes without resorting to courts, and this is actually a more expedient way. The reason why it may now be included, actually it's encouraged right now, so that other investors, especially foreign investors, will be enticed to set up corporations or to invest in the Philippines, because they know that if prior to the revised corporation code, prior to encouraging arbitration as a means to resolve disputes, they know that going to court is a tedious and very expensive process. Not to mention that it's very time consuming. Okay. So what are bylaws? Bylaws are rules and regulations to regulate, govern, and control its actions, affairs, and concerns. In this concerns stockholders or members and the directors and officers. No, this is in relation to each other and in relation to the corporation. So if you will notice, it's an internal rule. Therefore, when it comes to the effect or the binding effect, to others, say employees or third persons who are not aware of the contents of the bylaws are not bound thereto. So they are relatively permanent, but in terms of hierarchy, you will see that what takes precedence, meaning what is at the top, are the laws and the Constitution, like the revised corporation code. Then next would be so it's the Constitution, the revised corporation code second, the articles of incorporation then the bylaws, and later on, and below the bylaws would be internal rules or board resolutions. Now, the bylaws, although they are right after the articles of incorporation when you talk about hierarchy, they are, if they are in accordance with the constitution, the law, and the articles, they are written into the charter of the corporation. So in a sense, it becomes part of the corporation's law. Now, why do I say that it becomes part of the law? This is just to distinguish bylaws from board resolutions, because board resolutions normally apply to a single act, like say to representing the corporation in signing and entering into a contract or in filing a case. Yan. Every corporation has the inherent power to enter into the bylaws. Now, again, I will repeat, the section 45 here of the revised corporation code does not specify the period within which to file, meaning the bylaws are not necessary to the existence of the corporation or to the valid exercise of the corporation's powers. Now, with respect to one-person corporation, particularly section 119, the law explicitly states that the filing of the bylaws is in fact not required. There are, however, peculiar circumstances attending the formation of a corporation which may impose the obligation to adopt certain bylaws, as in the cases of closed corporations organized for specific purposes. And we'll get to that when we get to closed corporations. Just take note that PD 902-A, the law reorganizing the Securities and Exchange Commission, gave the SEC the power to suspend or revoke the franchise or certificate of registration of a corporation once it fails to file the bylaws within the required period. Now, technically, because of Section 45 of the Revised Corporation Code, which removed the period, in effect, that presidential decree, that law on the SEC, might not be operative anymore. So the SEC, it would be best for the SEC to issue the appropriate regulation to harmonize the revised corporation code and this PD 902-A, kasi both are laws. By laws, I mean LAWS, ha. Okay, so what are the limitations when it comes to adopting the bylaws? Although it is an inherent right, it must be consistent with the Constitution, the laws, and the rules and regulations. It must be consistent with the articles. It must not be contrary to morals and public policy, and it must not disturb vested rights or impair contract or property rights, or it must not create obligations that are not allowed by law. Okay. Let me explain them one by one. Now, when you say it must not be inconsistent with the revised corporation code, an example would be creating a provision where there is a permanent seat in the board. That's not allowed because the code requires annual election of directors. What else? The bylaws cannot transfer executive responsibility to managing directors. Why? Or to corporate officers alone as a means to evade the director's liability, because the revised corporation code specifically provides for liabilities of directors in certain instances. Okay. How about examples of instances where the bylaws cannot be contrary to the articles of incorporation? These are reflected under section 47. For example, the bylaws cannot specify powers that are not expressly provided for or implied in the articles. For example, if the power to guarantee debts of the corporation is not provided in the articles, meaning it's not one of its purposes, a corporation, the articles of the corporation does not state that it can guarantee debts of other corporations, the bylaws cannot authorize the corporation to do that. In other words, diba, if you remember what I mentioned, ultra vires acts are acts that are not illegal per se, meaning they are not against the law, but they are outside the authority of a corporation, the authority being written or stated in the articles of incorporation. If an act is ultra vires because it's not in the articles, the bylaws cannot cure that defect. what the effect that the act is ultra vires just because it's in the bylaws. I hope that makes sense. There are also other matters that need to be stated in the articles instead of the bylaws. For instance, numbers of shares, par values, authorized capital stock, subscribed capital stock yan. So, although we're not talking about the powers of the corporation, if the corporation did not state it in the articles, and files it with the SEC, they can say later on, it's okay, I'll still file it because I'll put it in the bylaws later on. That cannot be because the law explicitly states the contents in the form of the articles of incorporation. And I'm sure you would know that soon enough because of our group work. No? How about not be contrary to morals or public policy? It only means that it must be reasonable and it must not be discriminatory, arbitrary, or oppressive. For example, although there can be additional qualifications for shareholders or for directors, it must be applicable to all. If you say it's there's a certain qualification to be a member of the board, it cannot be just two seats. It has to be across the board. Otherwise, it would be discriminatory. And how about when I mentioned that it must not impair vested rights? I'll give you an example. When you say vested rights, it's not just the rights of stockholders. We're talking about the rights of everyone, even third persons. Okay, in the case of Thompson versus the Court of Appeals, the court said that you cannot give an absolute restriction on the right to transfer shares. And then another one, in another case, the bylaw should not undermine the security of tenure of an employee by stating in the bylaws that an employee's position is abolished. Diba? Because there's security of tenure when you, for those of you who want to take up law, you will see that under the labor code. And so again, I will repeat, the binding effect is not applicable to employees who have no actual knowledge of the provisions of the bylaws. The same goes for third persons. Third persons are not required and are not presumed to know. They don't the bylaws. They are not even required to investigate by looking into the bylaws. This is different from articles of incorporation. It's best that third persons look into the articles to see if before they transact with the corporation, they can check if the corporation is actually authorized to enter into a contract with them. In one case, the provision in the bylaws enumerating the who can be signatories to a contract are not binding on third persons who signed a contract with, say, a chairman. In the case of PMI Colleges versus NLRC, the third person signed a contract with the chairman. They did not know that the bylaw stated other people, particular people who can be signatories to the contract. So in that case, the Supreme Court upheld the validity of the contract even if it's the chairman who signed it. Let's just go over quickly again particular provisions of the contents under Section 46. For example, under letter A, the time, place, and manner of calling and conducting regular or special meetings of directors or trustees, since the word may is there, meaning if it's not stated in the bylaws, then the default, would be sections 49, 50, and 52 of the Revised Corporation Code when it comes to meetings of Board of Directors or Board of Trustees. How about letter C? Let me just show this. Yan. Quorum. When it comes to quorum, in the absence of any provision requiring the quorum, then what would apply would be Section 51. Okay. How about letter E? Form of proxies. If it is not provided, if a particular form of proxy is not provided in the bylaws, then what would apply would be Section 57 of the Revised Corporation Code and Sections 20 and 20.5 of the Securities Regulation Code. When it comes to letter G, the time for holding annual elections of directors or trustees and the mode and manner of giving notice thereof. Is it there? Yeah. In the absence of any provision, if it's not stated in the bylaws, then the rules under Section 52 would apply. Let's go to letter I, the penalties for violations of the bylaws. If there are no penalties stated in the bylaws, then there is still recourse. The corporation can still file an appropriate action in court. And in case of stock corporations, as I will repeat again, although it can state the manner of issuing stock certificates, it's always subject to the liability, to the limitation that stockholders may not be deprived of their right to transfer their shares. Once the bylaws have already been passed and a certificate has been issued by the SEC, there can still be opportunities to amend, repeal, or to adopt new bylaws. And that's under Section 47. If you will notice, it is harder. The voting requirement is harder, meaning it becomes 2/3 and not just majority, if the stockholders or members want to delegate the power to repeal, to amend, or to adopt new bylaws to the board. So you will notice the intent to make it difficult to delegate the power to the board, because that delegation or that authority vested to the board can be taken away by the stockholders or members using only a majority vote. So just take note of that. If you look at the first paragraph, there's majority, then there's 2/3, and then there's another majority. That's what it means. So Section 47, let me check. Yeah, so Section 47 until here talks about two ways to amend, meaning one through the majority vote of the board and the members or stockholders, and two by the board alone if that power is delegated to them. Now, before we end this title, let me just add other types of provisions under the bylaws that are not allowed. Diba, if you remember, we mentioned that as long as the minimum requirements under the law, say in quorum, are met, the bylaws can actually increase. For example, qualifications, diba, it can be increased as long as the minimum qualifications under the law for stockholders or members of the board are met. However, there are times that increasing is not always allowed. For example, while the bylaws may provide for a greater number of votes, say in certain actions, a unanimous vote is never required. Actually, in my opinion, it shouldn't be. Why? Especially for ordinary corporate acts, sometimes it would be difficult to require unanimous votes because it can be argued that it is unreasonable as it will cripple the operations of the business. I hope that makes sense. And then last one, let me just give an example taken from a Supreme Court case. Mr. S worked with the corporation as administrator. His contract of employment was not renewed after it expired, but he continued working for the corporation even without a written contract. Now, 4 years later, the corporation amended its bylaws by making the position of an administrator, meaning Mr. S's position, coterminous with the term of the board that appointed him. Now, later on, Mr. S was terminated because the corporation said his term was not renewed when the board of directors were changed. Kasi if you remember, board of directors are elected every year. Now, what happened was that Mr. S filed a labor complaint for illegal dismissal. It reached the Supreme Court. Now, the Supreme Court ruled that amendments to the bylaws, meaning turning the position of administrator into a coterminous position, impaired the obligation impaired the vested right of Mr. S. Again, as I mentioned earlier, he is a regular employee who is entitled to security of tenure. So that ends Title 5. Mabilis lang. So we'll move to Title 6.